Okay, today we're going to talk about the parole evidence rule. It may seem strange, but rules like the statute of frauds and parole evidence rule, uh, you know, the parole evidence rule is a rule, and the statute of fraud is a statute. So this is actually a true rule. But neither of them, I think, existed at the very early days of contracts. They were simply developed by the common law, in some sense, in that the statute was indeed passed by Parliament. However, Parliament was seen by the judges as just an adjunct to the courts, and so and the statute, and they seem to think that too in terms of Parliament. Anyway, what is the best? What when we get into this talking about the parole evidence rule, I think it's best to start off with the question of what is the best evidence as to the parties' agreement. What did they agree to? Would the best evidence be what they testified to? Obviously not, because what they testified to may be two different stories. Frequently, and honestly, it may be an honest disagreement that they don't remember exactly what their agreement was. As a matter of fact, at the time, they may not have been clear in what their agreement was. One virtue of having a writing would be that it would make it clear, and that's what the parole evidence rule and the statute of frauds deal with. The statute of frauds requires requires a writing only, however, in certain contracts. Parole evidence rule can be used whether or not a written contract is required. It's sometimes very good if it's an important contract and you don't want to have any confusion, you don't want to have hurt feelings. It's maybe a very good idea to put it in writing. So what is the best evidence as to what the parties have agreed to? Their actions? Well, that's certainly an important element. So we look to actions in terms of the objective rule. Are there past dealings? Well, those also are important, right? Or is it their agreement itself? Now, maybe that is the best, although the other things are important, and they may come in terms of understanding the contract in terms of its terms. But we should first look to the writing before we get into what their actions were, what they did, and before we get into what their past dealings. Let's look first. The courts will just basically look first, as a rule, they're going to look first at what the parties actually wrote down. Okay, this is a hypothetical. I'm going to put my glasses on it. I've got this little, I think I'm going to increase the font on this for you when you go to my website, that you can read these slides a little better without having to put on glasses like I do. Anyway, Arnold has negotiated the purchase of the house of his wife's dreams. In other words, his wife wanted to have this beautiful California ranch house. That's what she was looking for, and he knows that. And they found one, and Ziggy, the seller, after they had agreed upon the contract price and all the terms of the contract, so in some sense they had an oral contract at that point. Of course, since it's a purchase of a house, it's sitting on land, therefore it has to be in writing, because contracts where land is conveyed have to be in writing if you're going to prove them in court. So both the seller and the buyer know that. Ziggy, the seller, insists that he prepare the purchase contract that they will sign in a week later, because they don't have a written contract now. And neither of them have the time and don't want to take the time at the moment to write it up. They want to sit down and have it written up nicely. Normally this would be done by one of their lawyers, but Arnold had volunteered to do it. He has legal training, and he feels he can do this himself. And Ziggy, on the other hand, says, well, I can do it too. And he insists, so much so that eventually Arnold gives in. But he tells Ziggy that he wants Ziggy to send the contract to him within 3 days of signing it. So we'll have 3 days to look at it. So he wants it, 3 days before, wants it on Wednesday. They're supposed to meet on Saturday. He wants to have it ahead of time so he can look it over and make sure it's right. And if it's not right, he's maybe not going to come to the closing, right? Or he's going to insist that changes be made in the contract. This we'll see is very important. At the closing, Ziggy arrives late with the contract. He didn't send the contract, okay? But Arnold shows up and Ziggy arrives, and he's late, and the contract and urges Arnold to quickly sign. Well, Arnold really wanted to do that originally. The idea was that they could quickly sign the document. Both of them didn't spend a lot of time on Saturday signing a document. But, you know, he would have read the document that he signed rather than any that was sent to him. You know, so if Ziggy sent him one, he might have printed it out and he might have brought that to sign. And if Ziggy wanted to sign it without looking at it to read it, that was up to Ziggy, right? He wasn't going to sign one that was written up by Ziggy and handed to him, printed out, and handed it to him and told to sign it quick because we have to leave. We have another appointment. That's not the way it's done, right? So Arnold reads the contract, and so rather than quickly sign it, he doesn't say anything. He simply takes the contract. He doesn't care about Ziggy, what Ziggy thinks. He's going to read the contract. Arnold reads the contract and finds quickly that the terms are not those they had agreed upon a week earlier. How does he know that? Well, he knows that because he took notes of what the terms were supposed to be. These were short notes. It wasn't a formal contract. It wasn't written as a contract, but he took the necessary notes as to what the important things should be in the contract. And some of the things that were in there are standard things that everybody gives anyway. So Ziggy is really very bizarre kind of person who's not only violating the terms that they've agreed upon, but violating terms that are standard to most contracts for the sale of land. So what is, this is going to lead to the parole evidence rule. He doesn't have to sign this contract, even though he had agreed to meet and sign it, because it's not the contract that he had agreed upon. What is the parole evidence rule? And it's important for him not to sign it because the parole evidence rule can be later applied upon it. Those changes that Ziggy made would be the contract. That would be the best evidence of what the contract was. If he, Arnold, and his wife signed it, and Ziggy and his wife signed it, then that would be the best evidence of what was agreed by the parties. Okay, so what does the parole evidence rule say? And this is now standard. I mean, if it's not in a statute passed by a state, all of it follows the common law anyway. It's certainly in all kinds of precedents in cases. What is a parole evidence rule? If all the parties have signed a written agreement, which document was intended as a full, final, and complete statement of the contract between and amongst the parties, then no evidence will be admitted to vary or supplement the terms of the such agreement. So these contracts are said then to be fully integrated. And what does that mean? Well, it means that you can't change the terms of the contract. That's what the word vary means. So, you know, so I read it to you, vary. So that means that's a shorter word than change. You know, and to vary or to supplement. So supplement would be to add to it. So you can't change anything in the contract or supplement anything in that contract once that's been signed. But the only way you could do that would be by both parties agreeing to change the contract. So a bilateral agreement, properly entered into, can change that contract. But normally you would need to have that in a separate writing at a later date. So later on, you can actually change the contract if both of you agree to the change. So one party might want some sort of accommodation, or both of them may have thought that it might be better to change the contract for one reason or another. Well, one way that might happen is if it's a normal thing in buying a house to have an inspection of the house. And if the house doesn't pass the inspection, whatever is wrong with it has to be corrected. And the party who's buying the house can insist that the correction be made before they go through with the contract, before they sign it. And so if that's the case, they may need to change certain things in the terms of the contract. So the contract normally states a date of closing. That's the date where they meet and sign. They're going to put that off if they haven't fixed the house. So, or if the seller may want to put off the date of closing if the buyer has failed in terms of coming with a certified check or a check signed by the bank. So if he doesn't meet his term, if either party wants to, then they may want to change the closing date rather than just simply cancel the contract. Or either one of them could just simply cancel the contract if they've been hurt by this. Obviously, the party cannot insist that a party do something that he's not really agreed to ahead of time. And at the time, he doesn't have to agree to something that they had these negotiations over that are separate from what was agreed upon. Anyway, so let's go on. So basically, these contracts are said to be fully integrated, which means, of course, that you can't change anything in it, and you can't add anything to it. That's what and notice also the terms. There is very specific terms that are used: full, final, and complete. The document has to be full, final, and complete. That is everything that's important. Every material term, every relevant term in the contract is there in the contract. Final, in that there's been no subsequent agreement separate from the original agreement that they're now signing. There's nothing else that's going. This is the final. There's not going to be anything after this unless they agree to it both. They both have to agree to change it later. But it's final in terms of that's what they think it's going to be at this point. And it has to be complete. So everything has to be in it. And it has to be signed by all the parties to the agreement. So if you meet all these ifs, so the ifs are important, if you meet all these ifs, you wind up with a contract that is fully integrated, that is whole. That's what integrated means, right? Something that's whole. So some cases, the contract itself may have what's called an integration clause, or sometimes called a merger clause. Some people call it an integration clause. I prefer integration clause, meaning that you made it whole, rather than a merger clause, which has a different connotation, but really it's really no different in terms of how it's interpreted. It basically means that the statement has been full, final, and complete, and now it's signed. A statement that the contract is or was intended to be full, final, complete, and final. These statements are called integration clauses. So, the statement saying that this is full, complete, and final, and that would be an integration clause. So you don't necessarily need to put that in the contract itself. The contract, if it appears to be full, final, and complete, can be enforced as full, final, and complete by the judge. But that depends upon his deciding that it is full, final, and complete, and how he interprets the contract. What if he doesn't interpret it as you did, that it was full, final, and complete? You might want to put this, and it's a standard clause that is in almost all contracts because of this. You might want to put that in the contract, so that would indicate both of you intended it to be a full, final, and complete statement of the parties' agreement. We'll see that it's not necessarily full, final, and complete, but we'll get into the exceptions later. Anyway, secondly, this creates a rebuttable presumption that the contract is fully integrated. Okay, fully integrated means that it is whole. It is full, final, and complete. It means that it will not be varied or it will not be supplemented by any other thing. And however, of course, now that's subject to the proviso that, of course, one can later on, by agreement of all parties, change a contract. But all parties have to agree to the change. So any party has a veto on a change. So let's say one of the wives doesn't like a change. She can say, no, I'm not going to sign that. So then there goes the agreement. Okay. So it creates a rebuttable presumption. Rebuttable, of course, means that you can produce evidence that it is not what it says it is. Okay. That there's something lacking, that there was a term that wasn't included, or that perhaps it's not clear what was said, as we'll see what the exceptions are. Fully integrated, and thirdly, the fully integrated contract or clause is enforced precisely and exactly as it is written. Right? So that's just simply meaning that's the best evidence with the parties. It's written in stone, right? No, it's on a piece of paper. It could be destroyed in a fire, but if you got the ashes, you can get experts to actually reassemble it, believe it or not. Or you can have the parties testify as to what it says. Or if you got a copy of it, you can produce that and say, well, this is a copy of it, and it's, and if you show that you had this copy and it was made from the original, then you can argue that that is the copy, and the court would have to rule on that. But the important thing to realize there is that although we oftentimes talk about the writing as being the contract, it is not the contract. The contract is not a physical thing. It's an agreement that's made between the parties. It has no physical existence. However, it is evidenced by this written contract that the parties have signed. So normally people talk of it, and lawyers and everybody knows that when you say the contract, people will, if there is a writing, will normally say, okay, here's the contract, and treat it as if that were the contract. The contract is what the agreement is between the parties. So it's a mental thing. It has no physical existence in that sense, but it is represented by a physical existence. Okay. So fully integrated contract or clause is enforced precisely and exactly. The intent of the rule then is to create a strong contract which is subject to exceptions only under special circumstances, which we'll get to in a bit. There are exceptions, not very many. Fully integrated contracts. Ideally, the parties will state the terms of their agreement completely and finally and fully. These are called the fully integrated contracts, and the terms cannot be changed or added to. So that's the ideal, right? I mean, the concept is, why do we have this rule? Is because we want the parties to have something that is going to be enforceable precisely as agreed upon. We want to have certainty. That's the whole purpose of having a contract, right? To have certainty that the other side will follow through, and that if he doesn't, you'll be able to go to court and get it enforced. Now, you can do that with an oral contract, but the court has to believe a oral statement as to what the contract was. And if that's disputed, one party says it's this and the other party says it's that, then the court has to deal with whether it believes either party and whether or not it wants to find a contract in existence or not. Because if he can't really believe either party, then maybe he'll say, well, since I'm not convinced by either one of you that you've really given me the contract terms, which would be a strange thing, but you can enforce a oral contract. And in those kind of cases, typically what you oftentimes will look at is what would you normally expect the parties to have agreed to. This particular contract with Ziggy doesn't even fit what you would normally think a contract would be, okay, for a sale of a house, because he departs from the standard form of contracts in substantial and significant ways, very relevant and material ways. Anyway, so now we come to the fact that you can have a contract that's written that is going to be given some deference by the court as to its terms, but maybe not full deference. That is, we come to partially integrated contracts, and these are not fully integrated contracts. There's something maybe been left out. If the parties, for some reason, omit a term or are vague in their presentation, then if it is consistent with their agreement may be found to be partially integrated. That, in other words, we've got some of the terms, but we don't have all the terms. We don't know what all the terms are. Or we have all the terms, but there's one term that is subject to different interpretation. It's ambiguous or it's vague. We're not sure exactly what the parties meant. One party says it means this, another party is interpreting it a different way. How do we decide who knows what's right? Well, there are ways of deciding what a partially integrated contract means, and we'll get to that too. In which case the court, if it's partially integrated, the court may hear evidence and argument supporting or denying additional terms supporting or denying a variation of terms, supporting an interpretation of terms one way or the other, or evidence that a change was made to a term or term. So in fact, you could have a contract, and like I said, you could actually, by agreement, if both parties agree, you could actually change the terms of the contract. What happens if one of the parties decides to change it on his own, crosses something out, blocks it out completely, so you can't even read it, you can't even know what it was that he said without getting some expertise in there and getting somebody to analyze the document, which may be expensive. How do you decide that kind of case? Well, maybe one party has a copy, you know, and if indeed the contract has been altered, whoever altered the contract has basically invalidated the contract as far as the other party is concerned. That is, the other party could say he altered the contract, and therefore, you know, I don't have to go through with the contract. He could say, you know, forget it. I'm not going through with it. But that may not be what he wants. He may want the contract enforced. So he will then try to prove what were the terms of the contract. And there are various ways in which that might be done. Like I said, one way would be actually to have some experts look over the document and somehow lift that underlying statement from the document as to what it was said. Or if you got a copy, maybe you can show what it was. And if you had taken the steps to verify that copy, that would be helpful. But you know, it would be in dispute. In the end, it winds up with the judge using his best judgment in those cases as to whether or not one party can say what it was that's been changed in this document. And obviously, you don't want to sign a document where somebody has changed it, because that could lead to later litigation. You don't want litigation, you know. And you certainly don't want to change it because you're giving the other side an out for denying the contract. And there may be damages. And arguments such as supporting or denying the additional terms existence or evidence that a change was made to the term or terms. So that's the special case. And oftentimes, more often than not, those kinds of contracts involve contracts in which some term which is necessary for the contract isn't there. So for instance, if you're selling a good, one term that is essential that you need to have in there, there's several terms that are essential. You have to identify what it is you're selling. So let's say you own two houses and you say you're selling your house to the guy. Well, which house are you selling? So if you didn't put that in there, the contract wouldn't be full and complete. You left out the address of the house. Or another term that would be essential in a sale of anything, not just a house. Well, yeah, anything has to be identified. But another thing that has to be typical in a sale is the price. What was it that was given for that house? What was given for that car? How much money were you going to pay? Were you going to sign some sort of loan agreement where you would be indebted to pay him over time? Were you going to give him something in exchange, so it was a barter situation? Were you giving him another car? Are you giving him a motorcycle and he's giving you his car? And maybe you're giving him some additional money, or maybe not. Maybe your motorcycle is just worth that much. So you know, you could have these kinds of things arranged. The price of a car is always going to be, typically there's going to be oftentimes several elements to it. Oftentimes there's the down payment, which can consist of the car, a used car being exchanged for the new car, plus maybe some payment of some money, and maybe that's all there is. You know, so the used car and the payment of money is enough to satisfy the seller that he's gotten a good deal, or it could be that there is a loan agreement signed, and so the seller is obligated to pay him according to the terms over time. So there's a promissory note, and he has to pay on time, otherwise he'll be in default, and the other side could maybe take back the car. Obviously, that's not what you want to do, and if you have co-signers, they may want to intervene and claim the car themselves, which means they would have to pay the amount that's due. if you're in that situation. So if the parties for some reason omit a term or are vague in their presentation, that is what we talked about, then it is considered with the agreement may be found to be partially integrated. And the court will hear changes in that. So, okay, move on to the next slide. Fully integrated contracts. Ideally, the parties will state the terms of their agreement completely and finally and fully. These are fully integrated contracts, and the terms cannot be changed and added to. Like I said, it's a good idea to have in there an integration clause. Although it's not necessary, you can still have a fully functioning contract without that integration clause. It just kind of creates that presumption that this is full, final, and complete. But the judge could still find that the terms are vague, or he might admit evidence to hear about the terms being incomplete. It might look obvious to him on reading the contract that an important term has been left out. For instance, now it's hard to imagine somebody would leave out an identification of a house, but that happens. An identification of a car, that happens. Usually you put the VIN number on there. That can happen, and so you might hear evidence as to the identification of the car if there is some other evidence that would provide that. And so we'll talk a little bit about that later. But he also, so for instance, things like in a sale of good, usually, oftentimes, if a merchant's selling goods, there usually has to be some term saying how the goods will be delivered. In some cases, it may be being picked up. In that case, you would put in there that it's going to be picked up by the buyer. He's going to bring his truck, and he's going to pick it up himself, right off your dock, right from your showroom, whatever. Okay, or he's going to put it right in the car right away. So oftentimes, but some contracts don't have that, and reasonably so. So if you're buying a computer, you might just simply pick it up and carry it out to your car, and so you wouldn't have that stated in the contract. In which case, I doubt then that you actually have a contract to sell, because the contract always looks forward to some future happening. And if you're paying him money and he's giving you the computer or whatever good that you're buying, then that's a sale. It's not a contract to sell. Okay. On the other hand, if the contract isn't complete, if you're going to get the item later, or even if you're going to pay it later, it may involve in the contract. If only the contract, that's the promissory note, is also a contract, right? So where you agreed that you'll pay him by credit. That's maybe talked about. That aspect of it is a contractual aspect. The sale itself is still a sale because you get it right away, and he gets right away. If you put it on the credit card, he gets right away a claim to that money. And that's oftentimes considered to be a sale itself, not a contract to sell. However, the contract is there in some sense because there is a future event. You're paying it in the future should you not have enough money in the credit card account. But usually they've checked for that already, so it's usually not a problem. So partially integrated contracts. So these are not fully integrated. They are partially integrated. The parties, for some reason, omit a term or a vague. Then, if it is consistent with their agreement, they may found or prove the contract by other evidence, and it's a partially integrated contract at that point. In which case, the court may hear evidence and arguments supporting or denying the additional terms' existence, or evidence that a change was made to a term or terms. So you don't want that partially integrated contract. Getting back to the Ziggy case, when Ziggy presents the contract to Arnold, he has a choice. He could walk out. He says, you were supposed to prepare this, you haven't done it, I take it you're in bad faith, and since you failed to live up to our agreement, which included that you would come to the, to the meeting, to the closing with, the contract as agreed, you insisted upon doing it and you didn't do it right, and therefore I'm not going to go through, I don't trust you. You may be tempted to do that. So I would be tempted to do that. You know, maybe the seller has had the house on the market for 2 years. He may have it on it for longer. He's risking something. Now, this can occur, did occur, I think, in some cases, with people who read a certain book that have advised people to do something called backdooring. Backdooring was sitting down and agreeing to contract terms and then insisting that you, I mean, that's basically what he's doing, then insisting that you prepare the document and you change the terms to something that you prefer rather than that which was agreed to. And and that book also went into terms of changing things that were typical of contracts that were the sale of a house, for instance. The things that Ziggy was doing, he possibly got the idea from that. Some of this was really silly. So for instance, Ziggy wanted to give not a good warranty deed, but a quitclaim deed, which is not a good warranty deed. It's usually standard to give people a good warranty deed, and most people will not buy the house unless there's a good warranty deed. So this is kind of a standard thing that you would expect to see in the contract. So, you know, I don't think Arnold would have any problem if hauled into court to say this was not the contract that I had agreed to. You know, you can see from it that it's incomplete. Although he says in there a deed, it's not the standard warranty deed, and it's nothing I would have ever signed. Why would I sign that anyway? And what was maybe really silly about that case was that Ziggy didn't need to do that. He had a good title to the deed. The only reason you would give a quit claim deed, warranty deed, if there's something wrong with your title, which gets back to Arnold's point that he might want to say, hey, I don't want to deal with you. You know, it brings into question, does he have a good title? But Arnold had already checked out the deed, had a lawyer look it up. And he was sure that, you know, if the lawyer was wrong, then he could sue the lawyer. And so, you know, that would be kind of silly. So what Arnold was doing was risking his chance to make the sale of the house. However, since what Ziggy was doing was risking the sale of the house that he made, but since Arnold's wife really wanted the house, Arnold wanted to go through with it. So what can he do? Well, he can change the document right there on the spot. Now, Ziggy might object, oh, well, you know, it's on my computer. I don't have my computer, and I printed it out, and we both have copies, and I don't have a printer, and come up with all kinds of excuses. Not a problem. We just simply change the document on its face. We make proofreader's marks for things that we cross out, and if we have to change things, we put insertions in them, sometimes with little arrows going out to the side saying A, you know, where you look on the back to see what A is, and, you know, B if there's another change. And in this case, he had changed so many things, oftentimes things recommended by that particular book, because Arnold had read that book and was surprised to find somebody stupid enough to try to pull that off. But Arnold went through with the case, but they changed everything in the contract, and every change was initialed by the 4 parties. Ziggy and his wife, and Arnold and his wife. All of them changed those right on the spot. I know because I was there. In which case the court may hear evidence and argument supporting or denying the additional terms' existence, or evidence that a change was made to a term or terms. So you can, you know, see that with these terms, they have to be correct. Exceptions, you know, which kind of give one a reason to say we don't have a contract. Evidence in establishing that the contract is void or voidable. So let's say you enter into a contract with a young man, and then he had showed you an ID that indicated he was an adult, but you later found out that he wasn't an adult, and so you confronted him with that, and he admitted it. You don't have to go through with the contract. Okay. And you can say, look, if you want to contract with me, go get your parent or go get somebody to be a co-signer, and maybe I'll deal with you. But I'm not going to deal with you on the terms of something that's either a void or voidable contract. In this case, it's usually a voidable contract. In some cases, let's say you go to a dentist You make the mistake of having him look at your teeth, and later you find out that he's not really a dentist at all, that he's not licensed, or he was a dentist, but he's no longer licensed to practice dentistry. That's, that's a void contract. That's a contract that's an illegal contract. He's going to provide services that are illegal to you and treat. He's already done that. He cannot even collect for it. If you paid him any money, demand your money back. He looked at your teeth. He practiced dentistry, and doing that, he's not permitted to do that. Because if you knew he wasn't a dentist, you might have gone to some other person to look at your teeth, and so you might want to have those teeth fixed sooner rather than later, right? So you could say, hey, I'm not going to pay you for your examination, your charges. I'm not going to pay you. Or if I paid you and you've collected the money already, you've got to get it back. And you can sue him if he doesn't give it back to you. Okay, so this is, you can preempt that contract. Evidence establishing the existence of a prior agreement. Let's say that you're buying a farm and you find out the farm's been sold to somebody else. When you check the title, it's been sold to somebody else. He didn't have a farm to sell, maybe, or at least not the one he's identified in the contract. I presume that you insist that he identify the farm on the contract, because he may have more than one farm. He can't say his farm. He may have two farms. Which farm is he selling? And you want more than a name. You want an address, and you want to be able to look it up in the records to make sure that that he's got good title. A lack of contractual intent by one of the parties. If somehow one of the parties can be shown not to have a contractual intent, you could get out of the contract on that basis also. Exceptions allowing evidence as to terms. So these are the exceptions we talked about. Subsequent modifications. Okay, if you go into court and somebody presents a contract that has been modified, you can show the modified contract and say that's that's not the contract, so you're modifying that you're going to have the terms changed. Let's say that the contract, that the party that you're dealing with was in possession of the original document. Okay, so all you have is a copy, and you're saying, Your Honor, that's not the original document. He has the original document, and he's brought an old document. This is a copy of the original document. Okay. And then there may be some difficulty, but you can then you could maybe argue about whether or not that's the original document. And so an incomplete contract, like I said, sometimes it pops right out, but some terms are just standard or expected to be there, and other terms may not be the usual terms. There may be something added. So, for instance, there might be some sort of repurchase agreement on buying a house. So I can repurchase this. The seller can repurchase it from me at some future date under certain contingencies. Perhaps, or maybe under no contingency. It just says he has this general right to repurchase the agreement. Why would you have something like that? Well, it might be that you would have that if, say, it was a family farm. And one of the family members is going to be the owner and run the farm, and the others will nonetheless expect to have access and something still to do with the family farm. So they still expect to do things on the family farm, maybe even grow crops and collect those crops themselves. This might not be uncommon in a family farm situation. You might want to have a lawyer write that contract up with you, because there can be difficulties in terms of that repurchase agreement. It should be maybe better spelled out, and we'll talk about that later, because I got a case involving that I want to talk about. Anyway, an incomplete contract would be another exception. So that's what we're talking about here, right? The incomplete contract. Let's say you say that the right to, I've dealt with this with restaurants where I represented restaurants, and I remember one of my first cases involved a young China person who had this restaurant he had been running for 4 years, and his lease was running out, and so he wanted to renew the lease, and he was concerned. I'd been coming to his restaurant, so he knew me, and he knew I was a lawyer, and so he asked me to help him with this, to renew his lease for him. And he was concerned. He told me that maybe the landlord would want to raise the rent because it was very low rent. Well, it was very low rent because this was in a very dead part of the highway. So this dead part of the highway had been bypassed by the interstate. And so he was doing good. He was attracting customers, mostly from the law school on the hill. That's how I met him. I went down there when I was in law school, and I used to eat sometimes. So I met him and made a friend out of him. He knew I was a lawyer, and somehow he trusted me. And I said, don't worry about that. He can't renew, he cannot increase your rent too much because this is a very depressed area. He has to keep his rent somewhat close to what he originally asked for it to be. It could be a little higher than what the average rent is here, but not too much it should be. He has to keep it within a reasonable thing. And there is actually, in some states, and this was in Kentucky, there is in some states a principle or a rulings that say that one in a business, a retail business like that, the restaurant's a retail business, right? In a retail business like that, you have to allow a party to renew the contract, you know, because these retail businesses depend upon repeat customers, right? You're a restaurant, you work real hard to build up a goodwill. So goodwill is people coming to your store. That is actually something you can add to your balance sheet. And then when you sell the house, when you sell the restaurant, you get some more money by the fact that you've got a steady clientele. So you can show the persons what kind of, how many people come to your store on a regular basis, and he knows that you've got some sort of regular clientele that, you know, and so this is the goodwill of your business. And so you would include that when you sell it. And you probably want to at some point sell it. It may be that at some point you want to retire, go to Florida. Maybe you'll open a restaurant in Florida. Maybe you just want to move. You know, maybe you want to go back to China. Whatever it is, okay? So I helped him with that, and there's also a good reason why people should contact lawyers. I also showed him that he had a valuable asset he was not using. And what it was is he had an alcohol license, which he was not using. I said, I know this is you want a nice restaurant here. He immediately, when I said, oh, you can sell wine and beer and even whiskey if you wanted to here. He said, oh, I don't want to do that. I said, well, you know, think about it. Wine is, for a nice restaurant like this, is something that some nice customers want. I'm not saying that you should open a bar or, you know, advertise that you, I'm not saying put a sign out in front that drinks are available here. You know, it could be that some people like to have a drink with their meal, and you might actually get more customers that way. And if nothing else, your alcohol license is saleable. So if you don't want to use it, you might be able to sell it, and we can do some research and find out how much you can get for this alcohol license. And it's a substantial amount of money that you can get for these alcohol licenses because they're only given it to a limited extent by the state of Kentucky. And so he didn't know that. So he is very grateful to me. And after that, I began to get business representing restaurants, and which was very convenient for me because I had a Chinese friend, and most of these were Chinese restaurants. And so we'd go in, and we would typically write off the cost of a meal as part of our doing business. So we would go to restaurants hoping that we would actually build up. He became my partner. C.K. Wong became my partner, and so we would actually go to a Chinese restaurant, order a meal for the both of us, and write that off because, you know, it was a way of promoting the business. You know, we would get to know the clients, and they would know we bought from them, and so they would likely maybe reciprocate if they had any legal needs. And it not only went beyond representing them as a restaurant, but maybe them as persons. So that's perfectly legitimate, I believe. I hope so. Anyway, which you would think it would be anyway, right? Okay. Okay, so exceptions, subsequent modifications, incomplete contracts, ambiguous or vague terms. So we'll need to talk about ambiguity and vagueness. Pre-contractual facts may be admitted to clarify intent of the parties. Okay? And so if there are ambiguous or vague terms, you can clarify it with what we call pre-contractual facts, and I'll go into that in a minute. But let me first say, what is ambiguity? You can look it up in a dictionary and they'll give you a list of ambiguous words. Don't be fooled. The list of ambiguous words doesn't include all instances of ambiguity or vagueness. You can look up vagueness, you get a definition. But ambiguity and vagueness exists whenever it is not clear, whenever the statement, whenever a word or a phrase or a whole sentence or maybe a whole paragraph is subject to two different interpretations, then you have either ambiguity or vagueness. So it just simply means that the contract is not clear, that it can be reasonably read as having more than one meaning, okay? And so some things cannot be read that way. Some things are made perfectly clear, and some things are difficult to make perfectly clear, and even accomplished, and writers who are very accomplished may have difficulty in getting things made clear. So very frequently, we are not typically used to expressing ourselves with as much clarity as I would want to see in a contract. We oftentimes say things in a very general way and believe that the other party agrees with us as to what it is. Okay, so what you would want to get then into the contract is what the party's real intent is, rather than having the judge pick between two different interpretations. So how can you find out what the party's real intent was? Well, that's where these pre-contractual facts come in that can help you. And so what are these pre-contractual facts? I'm going to talk first in terms of a certain case. I call it the chicken case. We only got 5 minutes. I'm going to go through the chicken case real fast. I don't think I'll be able to get to some of the things that I mentioned earlier, but I want to do the chicken case. There are in this case, there is a contract involving 3 shipments of chicken of 2-week intervals. So there would be 2-week intervals between shipments. The first shipment, the chef goes out and inspects the chicken that were delivered to the dock, and he approves of them. That's what he does. That's part of his job, is to approve of food coming in. So he approves of them. Nothing wrong with the chicken. The second shipment arrives. The chef goes out, looks at them, and says, "This is garbage." Turns out some of the chicks are sick. Some of them are scrawny, that don't have much meat on. Some of them are just needing to be thrown in the garbage. They're not suitable for broiling or frying, and sends it back. And the seller complains that in the contract it doesn't say anything about the chickens being suitable for broiling or frying. And you're going to argue in this case that this is an assumed, presumed fact. The seller maintains that goods to be delivered were described as chickens, and these birds fit the dictionary definition of chicken, and therefore are conforming goods. So that's not persuasive that it's actually that. The dictionary definition isn't really the standard. It's what a reasonable person would think about these chickens, which are garbage. Okay, the chef was right to call them garbage. That's what they were. And they presented 3 kinds of facts, pre-contractual facts. Okay, prior course of performance. Let's start with trade usage. Trade usage is the least persuasive of these. On the slide I do a different thing. But trade usage is used only when the other pre-contractual facts and the contractual terms cannot be reasonably interpreted, and either of the 2 other kind of pre-contractual facts is not available. So you don't have anything else. You can go with trade usage. What would somebody in the trade, in a restaurant selling chickens, what kind of chickens would they buy? And I'm pretty sure you can find some experts who say that restaurants do not buy chickens that are fit for garbage, fit for only putting in the garbage can. So I'm sure you can get somebody to testify to that. And now the other side may have somebody else to testify, but then the judge can pick between who he believes and who he doesn't believe. And I think you'll probably win. You want to take a picture of the chickens so you can show what they look like. And you might want to have the chef bring other people out, maybe some of his other some of the busboys or something out to look at these things and say, would you eat this stuff? Okay. Now, the other two, the next one we're going to talk about is course of dealing. This provides a good or strong evidence of the party's intent. And what this is that the parties had had a contract before this contract. And we're not talking about the first delivery, we're talking about a previous contract. And in that previous contract, they had delivered chickens that were suitable for broiling and frying. And so therefore, you would expect that when they contemplated providing chickens this time, that the parties were contemplating sending that kind of chickens. So this is how you use these facts to show what the parties had in mind when they did it. They thought it was going to be a deal like the other deal. And then the best evidence, however, is prior course of performance. This is considered to be the best indication of what the parties intended here, and it's in this case because there was a previous delivery of chickens, and in the previous delivery of chickens they had delivered chickens that were suitable for broiling and frying. The chef had accepted them, and so these are the three things that you use to settle that question. Sorry we couldn't get into more depth on parole evidence rule. Maybe at some point we can do that, but thank you. You'll see it, some of it on the you won't see all of it on the slides that are going to be available with the PowerPoint, with the video. Okay, so I always provide PowerPoint slides. Thank you.